To continue with our look at the trademarks, which is one of the key tenets or key branches of intellectual property that we should be aware of. So we said a trademark can be anything from a name, a smell, a combination of colors, a combination of letters and numbers. It can be in 2D, 3D. There are various forms of trademarks that are there that we use. And the requirements for trademark protection is one, it should not be deceptive. If you have ever visited these Chinese shops or a downtown shop, you will see, you at one point in time having seen this confusion being created on the Adidas trademark, where you see shoes being written Abibas, or I think the popular one is also in the phones market, where you can see a very funny spelling of Samsung. So one of the key things is that when you want to file for trademark protection, it must not be likely going to cause confusion. The trademark must not also be against the laws of the land, or it must not be against the laws of morality of the land, or must not be of a scandalous nature. So it's very important that when you file for protection, or when you want to file for protection of a trademark, it is in line with the laws of the land. And also the mark should not be prohibited. So these are some of the key issues that you consider when you want to file for trademark protection. Plus, it must not also have been previously used or previously registered by other users. You know, there are trademarks that are created by use without necessarily being registered, which became known, which will become popular, but without them being necessarily registered. So when you file for protection, you need to be aware of those things. And there are various routes, or not various, the three routes for IP protection. They still apply to trademarks with the national route, determined by the relevant laws of the country. For example, in Zimbabwe, it will be the Trademark Act that governs that. Then the regional route, which for Zimbabwe will be done through the ARIPO in line with the Banjul Protocol. The international route, which is governed by the Madrid Protocol. So those are the three routes for filing for trademark protection. And the term of trademark protection, the duration standard internationally is 10 years, though there are some countries that have a 7-year duration. And the good thing about trademark is that renewal is indefinite. So you see some innovations, or some preferring to protect their innovations with trademarks, because they know very well that trademarks have indefinite protection as long as the relevant renewal fees are paid before the expiry of before the expiry date is reached. So that's all we can talk about trademarks now. We can talk about trademarks for now, since we are just doing an introductory talk to the various components of intellectual property. Then the next item that we just want to touch on is the other branch of IP, that is copyright and related rights. So basically, copyrights protect literary and artistic works. And by literary, we refer to written works. Anything that is written is protected by what? By copyrights. So copyrights, you have no registration process or any form of filing that is required for them to be protected in most countries. they are automatically granted on protection. I know we have countries like the United States of America that have put in place systems for the registration and for the protection of trademarks. And the reason why they do that is copyright, it's big business, it's big money. So once you have systems for monetizing your copyrights, I think the only way for you to ensure that there is maximum utilization, I think registration is a good thing, though some might argue otherwise. So these are some of the examples of copyrights that you cannot, or some of the works that can be protected by copyrights: books, dance, singing, broadcasting, images, sculptures. So copyrights protect quite a number of works. And the duration for copyrights, it's normally the life of the author plus 50 years after the death of the author. So if an author lives for 100 years, it means the copyrights will be in effect for the duration of his life. If he lives for 120, they will be in effect for the duration of his life, plus 50 years after his death. And I know there are countries that have also increased the term of protection to plus 70 years. This is because copyrights, their value will never end. In the works that are copyrighted, there are so many ways of exploiting them. For example, an author can write a book. Today, it can be adapted to become a movie, which means on an already existing work that is copyright protected, which is a book, we are now creating another work that can be copyright protected again. After maybe creating a movie, we can even do an animation and create kids cartoons from there. We can translate it into other languages. So there are so many ways of monetizing copyrights. That's why you see these countries are increasing what? The lifespan of protection of copyrights. Then let's talk about geographical indications. Indications of source, indications of origin. You know, some products have got value because of the place they originate from or the place they were made. Some products they've got less value or immediately lose their value once people know where they are made. So geographical indications allows or enables us to identify the source of a product. Where has a product been made? Made the product? Are they the authentic or the correct makers of the products? Made in China, made in Zimbabwe. All those are what? Geographical indications. Then there is another form of geographical indication which is tied to the quality that is inherent in a product because of the environment or the place where it was made. So this is called an appellation of origin. So we know that Tanganda is only made in Zimbabwe and it is produced in a special place called Tanganda, which is found in the eastern highlands of Zimbabwe. And the taste of Tanganda is different from any other tea that you might find anywhere else because of the environment where Tanganda is grown. So it becomes then an appellation of origin because the taste or the environment or the climatic conditions that are responsible for the growth of Tanganda contribute to what? To its quality. We have Mazoe. It's found in Zimbabwe, and these are oranges that are grown in a place called Mazoe in Zimbabwe. So it becomes an appellation of region because the taste of that mazo is only unique to Zimbabwe. We have a lot of other geographical indications or appellations of regions. We will look at this in detail when we delve much into geographical indications. And the protection routes, they are the 3 routes that we've previously talked about. So dwell more on geographical indications in detail in our future lecture. Then the other form of IP protection, we have what we call trade secrets. Unfortunately for this one, there are no laws or international agreements or regional agreements that govern the space for protecting trade secrets. Trade secrets are protected by ensuring that you are able to protect that information or that innovation that makes your product unique or that gives your product a competitive advantage on the market. So one of the best well-known kept trade secrets is the formula for Coca-Cola. And that product is protected by a trade secret. So you realize Coca-Cola, the formula for making Coca-Cola is protected by a trade secret. Then the name Coca-Cola is protected by what? By a trademark. Probably the bottle for Coca-Cola may be protected by what? By an industrial design. So already, if you are to look at the product Coca-Cola, you can see there about 3 forms of IP that are protecting the product Coca-Cola, which is maybe the industrial design for the bottle, the trade secret for the formula, the trademark for the name Coca-Cola. So what is key is that the formula for making Coca-Cola is the one that gives them the competitive advantage. And they have to put in measures in place to ensure that formula, that information is never shared or released. So probably they will sign non-disclosure agreements with their workers, and even in their contract, they will probably sign contract that even after you leave our company, you cannot be allowed to work in an organization that deals or makes beverages. So these are now the mechanisms that you put to ensure that you protect your trade secrets. So advantages of trade secrets as compared to other forms of IP, they are inexpensive. It's only the ability to keep the secret that is very important. There are no maintenance costs. There is no registration process to be followed. So what is important is just, are you able to keep your information securely and safe? However, the disadvantage is someone might reverse engineer the formula, let's say Coca-Cola, because there is no other protection mechanism that they've put on the formula. Someone might reverse engineer it, or an employee may leak it out if they do not have strong measures to protect it. So it means once that information is in the public domain, your competitive advantage is now gone. And also sometimes it's difficult to enforce, especially if you have a high staff turnover. So if you have a business that is built on a trade secret, it's very important that that business must have a low staff turnover. So I think for now, in terms of introduction, this is all there is. If you have questions, you can throw them in the comment section, then we'll attend them to the questions. However, just out of interest, I just want you to think of what IP assets are at risk in the cyberspace and how can you protect them. So I want you to identify the IP asset, the cyber risk that is there, and the mitigation measures that you can put in place to protect that. Thank you very much.